Aaron, welcome to the September 29th, 2016 session of the Prescott Planning and Zoning Commission. I'd like to welcome everybody. Looks like we have a quorum, so I'm not necessarily going to make our introductions, except I'd like to welcome Mr. Lamerson, City Councilman, here today. Is there something significant about September 29th? Why is that date? Is it?
Maybe it's your anniversary.
Can't always have something to say, does he?
Not again.
Oh, boy. Okay, we need to approve the meetings, the last minutes.
I so moved.
Do I have a second?
Second.
Is there any discussion? No? All those in favor, raise your hand.
Aye.
Okay. The minutes are approved. Okay, the second regular action item, community residences presentation.
Good morning.
Good morning.
Commissioners. I want to give you sort of a brief update on where we're going with community residences. First, one that's probably most pertinent to this body is on October 11th, this text amendment will be brought forward to the Land Development Code, will be brought forward for council consideration. It's a relatively minor text amendment to the Land Development Code. It redefines or revises the definition of community residence, and really the primary purpose is to deal with the meals issue. What's come up during the course of this process is that a few of the community residences don't provide any kind of meals, food service, or anything like that, and in lieu of that, they literally drop their residents off at some sort of social service or charitable type dining facility, what people may refer to as soup kitchens, but I don't know if that's PC anymore. So in order to, and that creates a pretty significant impact or demand on the ability of that facility to then provide food, because the tendency, again, anecdotally, but the tendency is for these residents to come in and sort of clean up, clear out all the food. So that's been kind of a complaint by a number of our social service and charitable type feeding food institutions. So we're revising the definition. In order to qualify as a community residence, basically a group home, there needs to be some type of process where meals are provided or access to meals is provided at the home. This is, and by the way, this is really consistent with Fair Housing Act, because if you look at sort of the preamble part of the change as a function of emulating a biological family, in order to qualify for Fair Housing Act protection, the residence needs to emulate a biological family. That's kind of the legal standard. If that group home or community residence uses social service or public social service type meals as a substitute on a regular ongoing basis, that really doesn't emulate a biological family in the sense. So this should be able to address that issue. Again, I'm going to go over in the other part of the city code, Title IV of the city code. On October 11, we'll bring forward an ordinance that deals with the operational or performance standards of community residences. And so the ordinance includes definitions. We added from the other day the definition of house manager. It defines operator, it defines structured sober living home, which basically is right out of the statute, except we inserted, rather than, the statute talks about structured sober living homes, including any building, facility, home. We actually just insert our definition of community residence so that there's a consistency between the Land Development Code and the city code section. It'll be actually section 4-11 or chapter 4-11 or 411. So I think we can sort of call this the 411 on how to operate a group home.
So it's a state statute.
Yes.
That's
State statute
is the basis for.
The state law, the new state law is basically an enabling type statute that authorizes cities to. I'm going to show you. I've got it actually in the whereas clauses. State statute. Oh, here it is. Right here. The statute number is 9500.38. So that's the enabling provision of the statute. Obviously, this compliance with other state and federal laws, as well as Fair Housing Act, ADA, are always sort of an overriding concern of this. So the ordinance will include definitions. We'll require a license to operate. There'll be a license application packet process, which has a fairly significant number of submittals that are required, up to 15, up to including 16 or 15 plus a fee. Once that's received by the staff, it will be processed in order of receipt. And if the applicant submits the proper documentation, a license will be issued. There will be a time lag to this. Is if it's adopted, it'll go into effect on January 1st of next year. There'll be a time lag in order to allow for current operators to basically fill out an application. 3 to 6 months is kind of the anticipated time frame for compliance for existing operators. If a new operator or if a new home is started, then there's basically you can't operate the home until the license is issued. There'll be some operating standards in sort of two forms.
Is one thing while we're there talking about licensing, is the licensing requirement here pretty much standard across the state with other cities?
Well, we're the first city in the state to do this. So
Okay.
there really is no, we're setting a standard, whether it's the standard or a standard. We're the first city to adopt if this gets adopted on October 11, we'll be the first city in the state to adopt this, and probably one of the very few cities in the country that has this type of operating performance standard type regulation or ordinance in a city code. What we've seen in the past is cities in Southern California have attempted to do something similar to this. Costa Mesa, Newport Beach, and others. Most of those are not going to withstand, most of those haven't withstood federal court challenges up into the Ninth Circuit. Some have made it through the district court. They all make it through the district court level, and then they get thrown out at the Ninth Circuit. Mostly on a Fair Housing Act type challenge, some ADA and some other constitutional, equal protection type issues. So. And many of those cities sort of try and meld a land use kind of regulation, which we already have in place, and we've had in place for now a number of years almost, and a performance sort of business regulation type regulation. They try and do it all in one fell swoop, and it's usually not advisable because they're really sort of separate. You're approaching the problems from very separate perspectives. The land use really deals with how the land functions, and the operational type regulation is really inside the house, how things work inside the house, and the performance standards that we expect.
Are you going to expect legal challenges?
Well, we always expect legal challenges. However, I think our ordinance, we don't all expect them. We're always prepared for any legal challenge, and we'll deal with the legal challenges that comes. If one comes, we'll deal with it because they're very fact specific. At the end of the ordinance, there is, like most of our land use codes and others that deal with housing, there's always a reasonable accommodation process that we have to have. It's mandated. So there is a process to give some relief to the strict application of the code. It has to be reasonable, it has to be necessary, and the burden is on the person requesting the reasonable accommodation to show why it's reasonable and necessary to get an exception. And that in the ordinance is a staff level function, and it starts off with the city manager or designee. So the actual kind of process or personnel who will review for a reasonable accommodation is yet to be determined. We'll defer that to the new city manager when he's on board.
I have a
Do
question.
you have another question?
Yeah,
Len?
John. As all of this came about from your sit-down meetings with the youngsters that came from Washington concerning the fair housing and the fact that we had certain provisions, and Tom and I and George worked with the Unified Development Code for years, putting that code together to meet the Fair Housing and American with Disabilities Act and provide for, and one of the major changes I remember at the time was we had a definition of a family, which was a group of people living in a particular private home in a single-family neighborhood that acted because they had like disabilities, and therefore we couldn't discriminate by having zoning laws to prevent certain types of occupancy in residential neighborhoods. And we got attacked by the federal government on that, as you know. They sent their minions here, youngsters, in my opinion. And what I look at when I review this now is that by adding language about serving meals, that takes care of it. Everybody's a family now because we're feeding them. To satisfy the federal requirements and make these changes whereby there's going to be some regulation over these group homes. I got you confused.
Yeah. Well, let me just break that down. The land development code, our zoning as it applies to community residences or group homes, is essentially allows for 5 to 12 unrelated persons with a disability to live together as a matter of right in residential zones. We have two types of community residences, what we call transitional, which is the length of time measured is months, less than a year generally, and then we have what we call the traditional community residence, which is a more permanent, indefinite period of time for a group home type residence. The practical distinction is a group home for the developmentally disabled has an indefinite period of time where that resident lives there. That is what we kind of think about when we think about the traditional group home for the disabled. It's an indefinite period of time for someone with a disability, like a developmental type disability. That is allowed as a matter of right in our single family residential because it really emulates more a traditional biological family in a single family zone. The transitional group home or community residence is more alike our sober living type homes. The typical residence time of residence there is 6 to 9 months, less than a year. That more emulates a multifamily type living environment where it's, in an apartment, it's generally year to year. People can live there for, 5, 6, 7 years at a time, but generally speaking, leases go year to year to year or month to month. So based on that rationale, we've made those two distinctions. We still have a separation requirement of 800 feet between community residences, group homes for the disabled.
I'm aware
That's
of all
all
these.
withstood the HUD challenge.
These were changes that were made after your visit with the group from Washington.
No.
We had a quarter of a mile. No, I spent years writing the damn thing. We had a quarter of a mile distance in the original zone. Was that right, Tom?
That's correct.
Well,
But it was modified.
Well,
And then it was
all of
modified.
if you're going back into like the 5-10 years ago time period,
Yeah.
none of that, the original ordinance that was adopted in the last 3.5 years had a 1,200-foot separation.
Right.
When the HUD investigated, when we had 2 HUD complaints, and the investigators came to investigate the complaints. One was a secretary initiated, which means HUD itself was the complainant. Another was an as-applied particular applicant. When we laid out all of the facts to the HUD investigators, they determined that because we had a significant clustering problem, that the intent of the Fair Housing Act, as applied to group homes for the disabled, is to disperse or is to integrate group homes for the disabled into the neighborhood to normalize their life. In other words, they are no different than any other family residence in a neighborhood, in a single family zone. However, when you have a clustering of group homes for the disabled, what it does is it creates what's called a social service zone or an institutionalized zone. And that goes against Fair Housing Act. In other words, what you're doing is you're essentially redlining group homes into certain areas, and you're not integrating into the sort of traditional, typical neighborhood. What you're doing is you're essentially clustering. So when HUD saw that, they basically signed off on our separation. We had retracted back the 1,200 to 800 based on the length of a traditional city block here in town. But at the end of the day, in the last 3 years, HUD rarely, if ever, approves a separation. So I think, because of the significant problem we had, and because, and I think you've all seen it, we had somebody do a study of our group home situation here to actually lay out the factual basis for the separation and for these zoning distinctions. HUD signed off on it, and since then, we haven't had any challenges to our zoning code. But the problem that has arisen as far as the change to the land development code definition is that because of some, again, I don't think it's the majority. I think there are a few operators who use the social service and charitable type feeding facilities as a substitute for providing meals. That can take them out of Fair Housing Act protection, because basically what they are is a rooming house, and a rooming house where people simply rent a room and don't live or emulate a family. You're not entitled. It's more of a commercial operation. You're not entitled to Fair Housing Act protection. So by changing the definition, by adding that meals issue into the definition, what we're saying is if you're going to demand single or residential zoning, or if you want to operate in a residential zone and you're going to demand Fair Housing Act protection, then you have to meet the qualifications. So really it raises the standard for an operator of a group home to operate in a single family zone and be entitled to Fair Housing Act protection. So it raises the standards, not lowers the standard.
It does, but doesn't the meals requirement issue kind of an end run to add restrictions, add method of restricting these homes?
Seems so to me.
I'm not sure what you mean.
Well, I'm saying is, I don't know, it just seems kind of obvious when I saw it. It looks like, oh, that's another way of restricting them.
No, it doesn't restrict, because what it does is it requires compliance. In other words, to be entitled to Fair Housing Act protection, you have to emulate a family.
That's the key right there.
So when a group home for the disabled is an institutional operation, it doesn't emulate a family. It's not entitled to Fair Housing Act protection, and they're not necessarily entitled to be in residential zoning type districts. Okay. That last part is all dependent on what the respective city wants. But in order to be entitled to Fair Housing Act protection, you have to emulate a family. In order to emulate a family, typically you can't simply have as your meals program substituting and using social service programs as the exclusive method of feeding family. Right. Now, that doesn't mean that a particular resident can't go and use a social service facility for a meal. But what we're asking for in the ordinance that's going before council is that part of the application will include their operating plan, which lays out what their meals protocol is. We're not saying there has to be 3 meals a day. Right. We're not saying there has to be 3,500 calories. We're not requiring menus. We're saying, what is your meals protocol for your residents? And the only limitation is that you're not allowed to use as an exclusive exception or exclusive substitute, a social service or charitable type meals server
Got it.
as your meals program. However else you want to do it, whether it's a allowance, whether you all cook together, whatever that is, lay that out. But we're saying if, in order to truly emulate a family and be entitled to Fair Housing Act protection, you must have some sort of meals protocol that's generally typically accepted of a traditional
On
family.
the application.
Yeah.
Okay. George? Go ahead.
I mainly eat Swanson dinners and frozen pizzas, and I just have a microwave and a refrigerator. Is that okay?
Yeah. Yeah, we're not delving into the actual, how many meals. Originally, the draft talked about 3 meals a day, and there was a debate, should it be 2 meals a day? But yes, we're not getting down into that level of weeds. We're saying, what is your meals protocol? The only requirement you have to meet is it has to be something more than simply we use social services and charitable services for our meals.
Okay.
And other than that, we're going to be hands off because it's impossible to develop a one-size-fits-all type regulation in that area.
By adding the meals to the portion where the original language to the ordinance was that a family unit where people with like disabilities could be considered a family. If you had Down syndrome, they could live into a single-family neighborhood because they have a like disability. If it was alcohol or drugs or whatever the disability was, if they all had the same problem, then they were considered a family, and we had a whole new definition of what a family is. And with all of this side stuff that you're talking about, to me, it gets down to one thing. You change the definition of a family to add they got to be together like a family, and that means you got to have meals.
No, well, we're actually not. We're not changing we're not defining family. We're defining. We're clarifying how to qualify as a community residence in order to be a use.
Splitting hairs, okay,
No,
all right.
not really.
I'll end. I'm done.
Okay.
Ken?
Mr. Palladini, we've sat through several sessions on the group home issues in the past, and I know we've had groups and committees together coming up with ideas on how to make them integrate to the city better than they had in the past. And as Len put it, we had the minions come out from the hinterland. Have we run this new idea past them, or are we just sitting in a closed room coming up with ideas and hoping they like it?
No and no.
Wow. Why haven't we?
Well, first of all,
On the first, no. Why haven't we?
First of all, the HUD doesn't issue advisory opinions. HUD is not our legal counsel. HUD will not preview proposed regulations. They just won't do it. It's sort of saying, well, why haven't you gone to the Attorney General of the state and asked him for an opinion? Simply because we can't. They won't give an opinion. So there is no sort of process.
Can't you call the guys that I didn't mean to interrupt, but can't you call the guys that came out and say, how's this work for us?
No.
It sounds like we're going through a lot of exercise hoping that our good ideas that we come up with in closed session will work.
Well, I was told by I've been told by a number of Army officers that hope is not a plan. This is not a hope. This is a well thought out ordinance. We have retained an expert in the field of Fair Housing Act and group homes, a guy by the name of Daniel Lauber. He's the one who did our study. He is probably the preeminent expert in
Big deal.
Fair-
I'm an expert too. I'm 100 miles away.
Well, okay. I don't know how to respond to that, but my point is that this is not we're not just throwing crap up against the wall hoping it sticks. This is a well thought, this has been going on for 6 months. We've been working on this, where we work in through our experience and knowledge, we've sent him drafts of documents to get his input. He's made suggestions and given us advice. And at the end of the day, I believe this is a very defensible ordinance.
I appreciate
if
that.
the council adopts it.
I
Does that mean somebody can't sue us? Sure, they can sue, but I think we have a very good position to defend.
I'm happy to hear that, because perhaps I should have rephrased my question to say, why do we feel that this is going to work? It still sounds like hope. I'm sorry. I think of the word we think and hope in the same way. We think it's going to work. We hope it's going to work. I hope it works. I'm just wondering if I just wanted to hear what background we've had to come up with this meals thing as the solution. And hopefully you're going to.
Well, again, the law is. George, are you going to step in?
Well, not about
Save
the
me?
law. The key issue is that the council's looking at this operational plan ordinance that Mr. Palladini's been talking to you about, and that operational plan has certain characteristics, and some of those characteristics have to match up with our zoning definition. So what we're telling you today relating to the meals issue is a matching of our definition with the requirements that are being imposed by council with their ordinance. So it's more of an attempt to make sure that we don't have disparate definitions across different codes.
Yeah.
So that's why we're touching the land development code. It's really not a change to any of the zoning related criteria. It's in fact, whether we feed someone in a house or not, single family, group home, community residence, whatever, is not a zoning matter. We don't care from a zoning perspective. But the definitions that we adopted need to match up with those other definitions in other parts of the city's codes. So that's the key provision for today.
And just to alleviate any concerns, I could spend hours going through the legal analysis we've done. I know you don't want me to do that.
No.
So it's unanimous. So my point is we've done a significant, tremendous amount of legal analysis. We've consulted with a renowned expert in the field. And at this point, we have a legally defensible ordinance. What the courts ultimately do is all going to be based on the specific facts that apply. On its face, there's two ways to challenge this type of ordinance: what's called a facial challenge, as written, or an as applied challenge. On its face, this is a very legally defensible ordinance. If it's applied in a way, especially with the reasonable accommodation process, if it's applied in a way that violates Fair Housing Act or violates ADA or violates equal protection, we may have a potential problem. But the role of the staff is to make sure that it's applied properly and legally defensible.
And I'm not criticizing your work, Janet. I mean, it just frosts me that all of this is caused because the federal government back in 1998 felt it'd be a good idea to pass a bill. And that bill had all of these here particulars in it. And now what they're doing is expanding it to provide more language, more changes, more definitions to satisfy a requirement, which is the unintended consequences of what they passed back in 1998. With the fair housing and the disabilities Americans with. Nobody complains in a neighborhood, and no one has ever complained to me that having 8 old ladies living in a house.
Stop! I gotta get you to stop.
I'm telling
You've given
you,
this example before, and it does nothing but potentially get us into trouble because you're discriminating amongst different disabilities. And so I gotta advise you to not go any further down that path. We've done this before. And with all due respect, I mean, you can't pick and choose which disabilities you like and which you don't like.
Hey guys, we're going around in circles here.
John, I commend you for what we've done. My fear was that we're going to continue to have this problem. I just wanted to hear you say what you finally said as to the background and how you got to this.
And at the end of the day, we haven't had any challenges to our current zoning code since HUD came out and basically signed off on it. And it's been over a year, 2 years
Almost
now.
coming up on 2
So we've got a very, very solid cutting-edge model, according to the HUD people, zoning code, as far as dealing with sober living type homes and group homes for the disabled. That is a model for other cities that have, again, similar factual problems or situations that Prescott does or did, in terms of the number of group homes we had in the city, upwards of 170, 200 at one point, the clustering problem we had. So I think
The social problems, and that's what I was referring to.
And so this new ordinance is not a zoning ordinance. It is a regulatory ordinance. It's a sort of a business regulation, for lack of a better term. And it is it is legally defensible, in at least on its face. Now, if it's applied improperly, we may have a problem, but that's our function.
Let's get back to specifics. I do have a question. The licensing requirement. Now, it seems like a very reasonable thing to do to, I'm not saying control the houses, but keep track and have some kind of information on how many there are in the city, and it makes a lot of sense. Now, how can we require a license of one particular business in the city and not require licensing on all businesses in the city?
Well, we are, because
How do we do that?
On January 1st, our business license ordinance goes into effect. So all businesses in the city, whether they are retail generators or whether they are doctors or lawyers and everything in between, is required to get a business license. It's a $35 across-the-counter issuance of a license.
Right, okay.
Beyond that,
remembered that.
Okay, so and that's why January 1st is the target effective date for this particular ordinance, and the rationale for regulating or requiring licenses of some businesses and not others is essentially health, safety, and welfare. In other words, if certain businesses deal with certain issues of health, safety, welfare, we can have a increased regulatory scheme over those businesses versus others.
Right.
And I'm not comparing one to the other, but we regulate pawn shops differently than we regulate regular retailer. Yeah. We regulate liquor distribution differently than we regulate soda pop distribution. So, and in this case, because of the factual basis we have of the lack of supervision and lack of management over a particular group of disabled people, people in recovery, or as a matter of law disabled, they are a vulnerable population, and the lack of supervision, the lack of care, and the lack of management over that particular population is a harm to that vulnerable population. So the facts, we have a great record to establish that. The state legislature and governor have decided the state doesn't want to regulate these homes, but will delegate that authority or will allow that authority to cities. So we have a factual and legal basis to adopt this regulation. And I think, like I said, what we've gone through is a very strenuous process to develop the ordinance to its current form.
So we're
the primary intent is to protect the resident client of the group home, and the secondary benefit by increasing supervision and management of that resident is that the surrounding neighborhood will also benefit.
Now, of course, Prescott becomes the guinea pig, right?
Yeah.
That's a choice that's a policy choice we have to make.
The licensing issue began with group home issues. But
sort of.
Let's not get into that. Sort of, yeah.
Mr. Chairman, can I make a comment?
Phil?
As the Mayor's Ad Hoc Committee co-chairman of the Sober Living Structured Rehab Homes, I've not only looked closely at this issue over the course of the existence of that committee, but I was a resident of Huntington Beach for a number of years and watched this whole issue develop over about 15 years in Huntington Beach, in Costa Mesa, now in Laguna Beach and San Clemente, to the extent that that part of California is now known as the Rehab Riviera. I've also looked at some of the aggressive zoning that has occurred across the country in Georgia and Florida and Minnesota, where aggressive zoning attempts were tried, failed, and it cost some of these communities hundreds of thousands of dollars, if not millions of dollars, in settlement costs. So I'm comfortable that Mr. Palladini and the city have taken a very methodical and thorough analysis of putting together this ordinance so that the potential for legal challenges is as minimal as possible and most likely to be upheld. But clearly there's no way to know until we implement it. And if we do get a legal challenge, then we have to defend it. So I think it's well thought out, it's thoroughly researched, and I'm comfortable with what they've done.
Okay, good.
And I will just wrap up by saying this is not on the agenda, so we can't discuss it, but for your future preview, we're bringing to the council on the 11th study session a vacation rental regulation ordinance, again, more in the business regulation realm, because as you all know, the January 1st, vacation rentals must be allowed in the city under our zoning. So both the land development code will be amended to reflect that requirement, and then the city code will also have sort of a performance operational type regulatory scheme presented to the council on the 11th, and happy to come back in October to discuss that with y'all if you're nice to me.
Great.
I was not nice.
Any commissioners?
been nice, John.
Any further questions, commissioners, regarding this particular issue? It's not a public hearing, right? So,
We've had 6 of those so far.
okay. Okay, thanks a lot. Appreciate it. All right, let's move on to number 3. This is a preliminary plat, 16-003 for Quantum Condominiums.
Thank you, Mr. Chairman. As stated, this is a preliminary plat because the proposed condominium development is condominiums, not apartment. If it was an apartment building not being sold as individual units, it would have been a site plan. So we have to do it as a preliminary plat. The location of the property is on Granite Street. Everybody knows this building is the Chase Bank. So it's just past the parking lot, north of the parking lot from Chase Bank. That's general location. The subject property is inside the downtown business district. So it is a permitted use in the downtown business district to have condominium development. To give you an idea of the type of structure, this may not be the exact one, however, it is one that was submitted for as a starting point, so to speak, for the development. The plan is to have the building be 2 stories high, but really it'll look like 3 stories, still within the height requirements. I think it's 30 feet high, with the parking underneath of the building. Three units on each floor. Kind of here's a floor plan. 6 units, and then the existing structure on the site would also be another residential unit. The applicant is proposing 17 parking spaces, only 15 are required. The building is 30 feet high. They will still have to comply with dark sky requirements, our sign code, all the other requirements, landscaping, none of that changes. And this is a condominium development in a downtown business district that meets the density and zoning requirements.
So it's not involved with the proposed amendment to the downtown business district?
No, sir, not in this case. This property
This
has...
falls within legal
Yes, it
density
does.
as is now?
This is one of the few that's actually big enough to do this.
Okay.
It actually meets the code. Most of the other properties downtown don't, but this one does.
Okay.
And the applicant is here for any questions you may have.
Good deal.
Applicant like to say anything? Any questions, commissioners? No?
Oh, I should have said that the water committee, the water subcommittee of the city council did recommend allocation of the required number of acre feet,
Bill, did you have a
1.75.
quick
I just wanted to make a comment. I know we're going to be looking on the next agenda item of some significant exceptions to our density guidelines at the moment. But I think as far as supporting some higher density development in an appropriate manner within the downtown business district, I think this development does meet those standards and I think is appropriate under our general plan. And it's something I think is should be encouraged.
Yeah, I agree with you, and we have encouraged that, and I like the project. Yes, sir.
Good morning, Mr. Chairman, members of the commission. I would be a fool to say anything. I'll be happy to answer any questions.
Well, I just need your name and address.
Oh, good morning. My name is Michael Haywood. My offices are at 115, isn't it? Yeah, East Goodwin. And yeah, we look at this. We see, you know, some of the thrust to development in the downtown area for residential use. We're taking vehicles off the street. People can walk to the restaurants, walk to the bars. You're not sending police and fire protection to the external environs of our Fairburg. Everything happening downtown. We see it as a real positive impact.
Except
of course, we
now,
would.
where am I going to park when I go to Rose's?
Well, you can sneak underneath there, and as long as nobody's in a space, at worst you risk towing, huh? Feel free.
I sneak into the Chase Bank now to park.
The sneakers will keep sneaking, Tom. By golly, that's the way it is. But any questions you might have, I'd be happy to answer.
Mr. Haywood?
What happened to your foot?
It's an interesting thing. I was mowing my lawn about 4 or 5 weeks ago, and some chunk of stuff came out and smacked me in the leg, and I thought, well, it'll be okay. I thought I sprained
I thought
my
maybe
ankle.
the Cardinals were having you try out for kicker.
Well, those silly folks at the hospital told me, no, your sprained ankle is a fractured tibia. So, ergo, we'll be gimping around just a little bit.
Ouch.
Minor detail.
Okay.
They used to heal
any questions?
easier.
Pacific, is that elevator legally a second exit?
Oh, I don't know. The elevator.
Yeah, I mean, there's only one stair for a
Ultimately,
three-story building.
Assuredly, again, we'll have to comply with whatever.
Okay.
We have the requirement of extending a city water main to boost pressures of et cetera, et cetera.
I think it must
so
be.
We'll comply.
It must be. Pardon?
We will comply. We have to comply.
This project began with a pre-application conference, and the building department has reviewed for
They did
architectural
review it,
standards.
okay.
Yes, sir.
Okay, I just, on first glance, a three-story building with one stair, I said, okay, but then I saw the elevator, so I think we're okay.
I think it's a great infill project for downtown, so
Yeah.
congratulations.
Thank you very
design.
much.
Nice design. I like it.
Thank you, Bill. Mike?
All right. We can take action on this.
Yes, sir.
Preliminary plat approval.
Correct. Recommendation, yes, sir.
Recommendation to send it on to the city council. I'm ready for,
I move to recommend approval of preliminary plat number PP 16-003.
Second.
I have a
Mr. Chairman?
Second? Yes, sir.
Forgive me for interrupting. The public may have wanted to make a comment, I believe. Somebody did.
okay. I didn't know it was a public hearing item, but,
It's not. They just
that's
flagged
fine
me
with
down, so.
Anybody in the audience like to speak to this particular
Since I made a point of
project? Deva?
Hi, Dava Hoffman with Dava and Associates, 310 East Union Street. I just want to say I do encourage all the residential uses you can bring into our downtown area. I've been saying that on my soapbox for a long, long time. We needed to support our downtown businesses and to also come into view with, I look around and we're all gray hairs, and more gray hairs are moving into the community. They've got to have a place to live where they can walk to activities and conveniences. Hopefully Sprouts is going to open in the downtown, because we don't seem to have the wherewithal to create transit systems. And, you know, baby boomers are all going to start being in their 80s in less than 10 years, and we need to think about what's happening. And the millennials like to live where they can walk to everything. And we need to encourage those people into our community, because otherwise Prescott will end up being nothing but a retirement home. So I encourage you to support condominiums and other types of residential uses in walking distance to things in the downtown. But keep in mind that they should be good projects and have some affordability, because the only condos we have so far are close to the $1 million range, and that's not very affordable for most people. And I know your next item is going to be talking about some changes to hopefully add to that. I think we need to also have some discussion about the building codes because of commercial zoning creating more expenses for residential uses, possibly if it's in a commercial zone. I don't really know, that's not my area, but I think that's something the commission should have a discussion about, so again, we can create affordable housing in the downtown. Thank you.
Okay, thank you, Dana. Anyone else? No? Okay, I have a motion and a second. I do want to say that this body has always encouraged, as many years as I've been here, has always encouraged increasing density downtown and getting more residential downtown. So we're certainly on the same page there. I have a motion and a second. All those in favor, raise your right hand, say aye.
Aye.
Okay.
Thank you, sir.
Let's go on to public hearing item number 1. Proposed amendment to Article 4 of the Land Development Code relating to amending overall maximum density.
Yes, sir. Thank you, Mr. Chairman. As you know, this is a final or a continuation of the meeting we had back in June. I think it was June 15th, where we discussed this agenda item as a discussion item, just to sit down and consider it. To go back a little bit for the public's benefit, the discussion is generally about residential density in the downtown business district. The downtown business district has a maximum residential density of 58 units to the acre. For multifamily development, you need a 7,500 square foot lot to get 3 residential units. Most people know that weekly we have pre-application conferences for development anywhere in the city of all types. And the discussion began with an application that somebody wanted to have 6 apartment units above their property or on their property on a 7,500 square foot lot. And as a result of that pre-application conference, I had to say, I'm sorry, you don't meet the residential density. In order to get more residential density in the downtown business district on a 7,500 square foot lot, the code requires these items in red. Number 2 would require, to get an additional unit, you would need an additional 600 square feet on the lot for another unit. If you are providing recreational amenities for the people living in that apartment building, not for the public use, but for the apartment building. Number 3 down there, if you wanted to even have higher density, you have to have a public-private partnership for the development, and you would still need an additional 530 square feet of lot space to get that additional unit. No one to date has used these provisions to increase residential density in the downtown business district. It should also be mentioned that in the downtown business district, this is the only zoning district that we have that has these provisions for increasing residential density. Every other zoning district has a straight residential density, not provisions that allow you to get there by providing some other type of amenity. As a result of all that discussion, we did take it to the Unified Development Code Committee, which forwarded a recommendation to move it forward, and that's why we went to you in June. And we also conducted a public or community meeting. I think it was back in, I don't remember the date right now, but it was back in the spring, where we had a good number of attendees. We sent out about 300 plus notices, and we had a room full of 20 plus people that came to hear it. Initially, people just wanted to find out. Some people were concerned about the density, but as it turned out, by the time I explained everything, people in the room were like, okay, that makes sense in general. So the general consensus from the public at that meeting was supportive. So here we are today. We're finally bringing it to you for a public hearing item to discuss with the public. The proposal would be to basically just delete these provisions and go with the straight residential density that's been in our code forever, similar to other zoning districts. The other thing that I need to mention with this request is at one of our meetings, this was the initial request to just delete these provisions and go with the straight residential density. At one of our meetings recently, somebody in the audience mentioned, well, since apartment buildings, sort of, they're residential, but they're commercial, they're treated commercially by building codes and things like that. Why do we have, in the downtown business district, why not just treat them as commercial setbacks rather than making them have setbacks that are currently in the code, as these items in red? Setbacks from the street, as you know, most of our buildings in the downtown business district are right up on the sidewalk or right up on the street, side by side. The buildings touch. So this came as an afterthought, so I decided to add it in. Community Development decided to add it in as part of this amendment request for this public hearing.
Okay, now as far as residential being treated as commercial, as far as the building department concerned, it depends on the building type.
Yes, it does.
So it's it doesn't automatically mean that if it's a downtown business district, it has to conform to commercial.
That's correct.
Building standards.
That's correct.
Okay.
So
thing, with the adjustments and the a list of requirements or allowable things going on with multifamily dwellings, I don't see anything on parking.
That's correct.
Why don't I see anything on parking?
If I could add one more thing before I address parking, it would be that we are asking that the Chamber of Commerce did, I think, submit a letter this morning to you in support of this amendment. But there are other organizations that want to weigh in, such as the Downtown Business Partnership. So we are asking, although you could take action or make a recommendation on this today, Community Development's sort of requesting that there's really no hurry on this. We could talk about it today, hear from the public, let the word get out, and then take this at your next meeting on the 13th of October for recommendations, continuation of the public hearing. As far as the parking goes, you're correct. There is no recommendation at this time to change the downtown business parking standard for residential development. New buildings would still have to provide the off-street parking. That was a concern that I heard at that community meeting, that, okay, increased apartments are fine, but we can't lose any more parking spaces. They should have to provide their off-street parking, just like the development you just approved a minute ago with Quantum Condominiums is providing off-street parking. So we're not proposing that at this time. This is an opportunity for the increase in residential density.
Good. There is in the past, we have considered parking, in another location, like adjacent,
Correct.
across the street, in lieu of. And that's still open to possibility, right?
Yes, sir. We still have provisions for off-site parking or shared parking agreements.
Good.
That are not directly on this property, but within a radius of the property. And we still have the provision for fee in lieu of a payment for fee in lieu.
That's right.
The fee in lieu was the big thing when we considered the lack of additional parking downtown to encourage more density, was that the property owner could pay a fee in lieu of providing parking, and the anticipation that these accumulated fees eventually would be used by the city in order to build, say, another parking structure in another part of town.
That's correct. And those provisions still exist.
That was the intent. Where is all that money?
Well, that's part of the issue. In order to get higher residential density, and then people having to pay the fee in lieu if that's their choice,
Right.
they have to provide these types of amenities, and it just doesn't happen. It hasn't been
So
effective.
it hasn't happened.
No, sir.
Okay.
No one
maybe
can get
this will
there.
help.
No one can get there with the current zoning the way it
This
is.
will help.
Okay, so thank you, and of course the public's here.
Okay. Commissioners, you have any questions?
I have a couple of questions.
Phil?
We are eliminating the 3 units per 7,500 square feet minimum requirement.
Right.
what will that result in as far as multifamily dwellings within the 58 dwellings per acre?
Excellent question. What I'd like to do is use some of the slides that I used at that community meeting I had.
While you're looking for your slides, I'd like to add, in all of this discussion, we're talking about the downtown business district only.
Yes.
We're not talking about the adjacent lands to the downtown district or other multifamily zoning in other parts of the cities, but it's specifically related to the downtown business district, which is, what do we got an acronym for? DTB or something?
Yes, sir, DTB.
Okay.
I understand that, and I know the community meeting with 300 potential invitees and 20-plus actual attendees is somewhat of a concern to me, because increasing density in the downtown district has such a potential impact on the historical nature of the downtown area. And having a broader understanding of the residents of the potential impact, I think, is more appropriate for notification and public input. I think that making some of these changes on some of these recreational amenities is probably appropriate. I think that supports private property rights and owners to be able to develop those properties without having to have those types of maybe unnecessary restrictions. But I also have a little bit of concern on the setbacks for residential development. I mean, I've seen some high-density apartment developments in other cities that are built right up to the sidewalk, and they look so institutional, where a commercial development blends in and looks acceptable, but these residential developments without any type of setbacks, I don't think that they really fill the expectation for residential development.
Well, wouldn't they go through the preservation in terms of compatibility with the downtown
Yes,
environment? So
the
that
downtown business district has a whole section on architectural design and historic preservation, but also to keep in mind from Mr. Good's comment is a good one. Initially, this only included the change in density, or it's really not a change in density, it's a change in the provisions that get you to the density. The thought about setback adjustments came later on in the process. So it's still, there's sort of two different requests from two different people. So just, you're right, it didn't start out that way.
Right, and that bothers me sometimes when you're trying to solve multiple problems within one proposal. I think they need to be considered separately and decided and discussed, and decisions made on those separately.
And that's why we're bringing it to you now.
And I think I would like to have you discuss a little further the setback that you're talking about. But the looking at the larger issue, Phil, is, boy, residential development in downtown has been stagnant ever since I've lived in Prescott. I can think of a couple projects that were done, and I think a lot of that is because of this restriction that we're talking about getting rid of. So.
Well,
I don't know how much of an impact it's going to make all at once, but boy, there's been nothing happening on residential in years and years, and we're
Tom,
trying to encourage it.
you and I and the others that were on those various committees and commissions years ago realized that one of the problems in the downtown business district was the fact that on residential, to convert one of these existing retail locations downstairs with potentially apartments upstairs, they had to provide on-site parking, and that meant they either had to knock down a portion of the building,
That's
or they had to
big issue.
which was a major problem.
That's why the in lieu
And
of
there was
was
and
developed.
then we came out with the in lieu of in order to encourage it. And as a demographic freak, I look at the numbers today over years ago, And one of the things that amazed me just recently is that youngsters, 16, 17, 20 years old, are no longer getting their license like we all did when we grew up and wanted a driver's license. Now their parents give them an Uber account and away they go.
That's correct. So,
So the living conditions
Or a
are,
skateboard.
I'm downtown, give me a small place to stay. I don't need parking. If I want to go someplace, send the car.
to get back to Mr. Good's comment or question, if we I sort of, at the public meeting or community meeting I conducted, I had a few options for them to consider. One of the questions that came up at that meeting was, oh my gosh, you could be talking about hundreds and hundreds of units. No. In the downtown business district, the eligible properties that are vacant are few and far between, as we know, if you take a walk around downtown. You're talking about 6 here, 3 here, 4 there. So that's one thing to keep in mind with this amendment. We're not talking about apartment complexes. If we amended the code to just go to with the base residential density on a 7,500 square foot lot, which is very typical in the DTB. That's all over town. We have 50 by 150 lots. It would end up with, as you show on the screen, 9 residential units, 9 apartments. Right now it would be 3. So if you remove the provisions, kept the base residential density at 58 units to the acre, when you do the math, you end up with 9.
What height requirement would that take?
Sorry?
What height requirement would that take to do 9?
We would be limited to the 50-foot height limit of the DTB. Then I also showed option 2. Remember the original pre-application conference meeting that kicked all this off was the gentleman wanted 6 units. So what if we change the maximum density to 35? I did the math backwards. That got to 6 on a 7,500 square foot lot. And of course, option 3 is to do nothing and leave it just like it is. So I gave some scenarios, some examples for the public at that community meeting. This amendment that came before you in your agenda packet today does not propose to change this 58 units to the acre, but if you did want to, that certainly is something that could be considered.
One, thank you for saying this is a discussion item, that we're not going to make any decisions. I think it needs more study. I agree with my fear is parking. Parking is always an issue. My office is downtown. You know, there's been times that some of my guests have had to park 2-3 blocks away. And that's tough. And if we don't do something about parking and at least have the fee in lieu, I don't know how that provides a parking space, but the assumption is the city has this pile of money sitting someplace. I don't think it really exists, but I think the fear for downtown is parking, and I actually think the setbacks, there needs to be some type of setback issue instead of eliminating all setback. I think apartments really are different than, I agree with Phil actually, than retail. So I like the fact that we got more time to look at this and maybe make some
Absolutely.
different points of view on it. But generally, I think downtown needs to have some more housing. It's always going to be more expensive. Downtown property is just more expensive. So I don't know how we do the affordable thing, but if that can be done, that'd be great. But I don't know of a building. I don't know. The 58 units to the acre is pretty tough. I don't know of a building that is 58 units per the acre.
Not in the DTB. It's not.
I don't think it's anywhere. We used to own and manage a 72-unit apartment complex, and it was on 3.5 acres, and people thought we were tight. So I don't know how 58 on an acre, whatever.
No,
The maximum density in all our zoning districts are seldom achieved by the time you add in parking, landscaping, stormwater
Ken,
management.
I designed apartment buildings in Long Beach, California at 160 units an acre. Okay, on a lot that was no bigger than 95 by 200.
Oh, I get the high-rise thing, but we have
Okay,
limits here.
so you can do it. You can do it. I think 35, which is a garden apartment, density, it would not be appropriate.
No.
For downtown, okay?
But anyway,
I
but
just
to
wanted-
summarize, I'm glad we got more time and more people are going to look at this. If you have some of the other information that you kind of showed on your slides, you could send to us, that'd be great.
Could we discuss the setbacks?
Sure.
Okay. What's the staff thinking? What are they proposing?
It was a request. We're proposing in this draft that the setbacks simply go to whatever the commercial setbacks are, which are 0 for the downtown business district. Again, that request came from a member of the public to say, while you're considering this, can you ask the Planning and Zoning Commission about setbacks? And out of respect for that person or all the citizens, we brought it forward to you for discussion.
Okay. I would guess marketing has a lot to do with that. I mean, you're not going to market an apartment downtown probably without a balcony, you know? I mean, you're not going to be right on the street, I would guess, if you're a smart developer. But let's talk about it.
Point out a couple of issues that are associated with setbacks. There are building and fire code requirements for certain types of setbacks that still apply. They would apply if you eliminate zoning setbacks. You're still going to have to meet these building and fire code requirements.
Building type.
Building types, but also openable
Right.
windows, egress, those
Right.
types of things will require some setback in certain areas. The compatibility issue that came up earlier, I think Mr. Good brought up, it is actually a two-edged sword. If you allow all commercial buildings to build to the property lines, especially the front property line at the street, and then you require residential to set themselves back, they are not compatible with the appearance of a downtown district. What you want is something that is traditional downtown. It's what we have here. We have one of the few traditional downtowns in Arizona, and you build to the property lines. That's the intent of downtown development. The intensity, the appearance, the streetscape, the walkability, pedestrian access, all of it is focused on the street in front of the building, not the building itself. We would want, for appropriate compatibility purposes, if you provide parking on site, that it come off of the alley on the back of the building. We don't want to see your parking. That's not compatible with a downtown development. In downtown, you have the building on the street in the streetscape. Much of the downtown is within a historic district or districts. We have several that are applicable. There's one immediately around the courthouse plaza, that there are several others in the downtown. They also will look at that type of compatibility as part of an approval through historic preservation. So they're going to discourage setbacks and encourage zero lot line
And aren't they going to act on this change also?
They will be consulted on it. It's a zoning change. It's separate from them, but they get a review of any building
Right.
design,
That's
so
what I
it does affect them, yes.
Well, okay. Anybody in the audience like to speak? Oh, I'm sorry. Phil?
I think George is
Okay,
first.
George.
There's a current project going on. Everybody knows who it is in the downtown, and the single-family residence. It's not a density issue, but I believe it went to the Preservation Commission, and they discussed the appropriateness of having it appear as though it's the commercial. And then in terms of, I don't know if it went to Board of Adjustment in terms of somewhat side setbacks.
It did. It
and
got a
some things
variance.
like that.
It went for a variance for
yeah.
setbacks.
So we handled it that way as opposed to modifying
Correct.
our code, which would be more of a permanent way of addressing those issues.
Right. Well, and again, one
No,
of the
it
things
doesn't
to
have a
keep-
setback, does it?
It does.
On the front, it's got a
It does.
patio out in front or something
Again,
like
right
that.
now, our code requires substantial setbacks for single-family residential in the downtown. That makes it look different than everything else in downtown. So we're forcing an incompatibility, appearance-wise at least, for residential. The intent of all of these provisions is to allow property owners to actually meet the requirements or meet the allowance, the grant of density that the code currently provides them. We granted 58 maximum units per acre, and then we applied some additional criteria that forbids you from ever getting there. So it was sort of a, we're going to give it to you with this hand and take it away with this hand situation. The setbacks are part of that. If you force a setback, then you're reducing density. There's a direct proportion
Well, everyone
between the two.
might not agree with that. I do. I agree with that. I think the
but if-
setback should be the same as commercial.
If you allow them to be the same as commercial, it gives the property owner the right to decide when they build or when they design. It gives us the right to encourage them to make it compatible, though we can't require it. So if we say your setbacks are 0 and you choose 10 feet, you're right to do so as a property owner and developer.
Right. And we can't dictate aesthetics either, as far as forcing a certain building look.
We can to a degree in the historic districts, but that's only to a degree.
Yeah. Okay, Phil.
Yeah, I mean, I totally get the historic preservation's responsibility in this area. But I want to make sure that the public in general doesn't think that we're approving this with the insinuation that the historic district is looking and saying, well, planning and zoning has already approved this. I think we need to look at this carefully. And when we look at a density change like this, we're going from 3 approved for 7,500 to 9. You know, that's a 200 increase in density. We just passed overwhelmingly our general plan just last year by 80% of the voting public. Whether they took the time to read the density issues in that, I'm kind of skeptical that they did. But nevertheless, it does suggest a support for increased density. So the question is, how much is that? You know, if we go from 3 to 6, that seems a more modest and perhaps reasonable support. 3 to 9 seems pretty dramatic. So they're just numbers, I realize. You can go from 1 to 2 and say it's 100.
If you get beyond, though...
But I think it needs to have more public awareness and public input before we make such a decision, because it potentially can have a significant impact on our downtown business district and the nature of this of our city.
I agree.
You know, Tom,
That's why we're going to postpone this for future, for more discussion.
We made a recommendation earlier today for the units next to the bank one.
Right.
When you look at them, they're extremely large. As a former developer, etc., 900 and something square feet.
Big.
My first house was 900 square feet and was 3 bedroom. It's a 1-bedroom, 1 bath and a half apartment, but it's 900 and some odd square feet. The 2-bedroom is 1,700 square feet. My thoughts downtown in increasing density is you have 500 square feet. You got a little bedroom, a bathroom, a living room, and a little efficiency kitchen, and there you are. It's not a 900 square foot large living unit or a 1,700 square foot 2-bedroom apartment. So, and I think developers looking at the ability to go into downtown are going to look at that market that says they only need 500-600 square feet for one of these little suites, and get the density up at the square footage.
Well, I think the 58 units would be appropriate for that too. See, when you're looking at only a 3,500 square foot footprint, you know, there's a limitation. But as soon as you get above a certain square footage or a certain size lot, it's immaterial. Then you've got any density you want up to the max. So that 3,500 feet thing really only applies to smaller parcels.
7,500, right.
Or the 7,500, yeah. So
George, do we have provision, can someone do a mixed use, retail on the ground floor,
Yes.
office on the ground floor?
We
apartments
encourage
above?
we encourage mixed-use developments in the downtown,
And-
both in the general plan and in the land development code.
And will this affect that?
If we had an existing building that had a storefront on the first floor and vacant space that they're still deciding what to do with it above it, this could help make that more pencil out better economically for them. If they had a 7,500 square foot lot and they had retail on the first floor, they could do 3 above. Under this provision, they could do 6 or 9, depending on how that code changes. So it wouldn't affect it in a negative way. It wouldn't change that at all.
And with the 50-foot height limit, I mean, that also, we're not talking, 5-story buildings or something. I mean, we're talking
The 50-foot height limit is not recommended to be changed. Of course, in the downtown business district, I should mention that we could go to 100 feet with an SUP, but the by right height is 50 feet.
Right. Jerry?
Frank, I'd like to go back to the parking situation. If, in fact, the parking is not satisfied on the property and they go off-site,
Correct.
does the developer then have to own that? The property where he's parking, does he have to have some kind of a ground lease? And what happens if the developer decides that he wants to do away with the parking? Then what happens? How do you satisfy the parking requirement if that happens?
The answer is that they could own a lot off-site and develop it for parking for their residents and restrict it that way. The other option is something called a shared parking agreement. The shared parking agreement is a legal document between the property owner, one property owner, and another one. So the developer for the apartments wouldn't have to own it, but they could enter into a shared parking agreement that would get recorded in the land records for use of those parcels. We have that now.
Yeah, we've done that a few times.
Yes, sir.
Not too often.
So there's no way that then that the parking would go away?
Correct.
Right.
The community development director would review the shared parking agreement, approve it, and then it would be recorded between the two property owners.
Phil, do you have something to say? Anybody in the audience like to speak? Deva?
Well, I think this is going in a good direction, but I think there are people who have not been able to review this yet. In our downtown, we have property owners who get notified, but most of the businesses are leasing space from property owners, and they don't always know about it. That's why the Prescott Downtown Partnership was formed. Its membership is made up of business owners as well as property owners. I sit on the board. It's a voluntary board. Kendall Jaspers is the director. He's had recent surgery, so he wasn't able to attend this morning. But coincidentally, we have a board meeting this afternoon at 3 o'clock. And I did talk to him last night. He has made a provision to have this item on their agenda. And I'd like to invite a staff member, Frank or George, to come to the meeting to explain it to that board. And I'm hoping you'll put off till October action on this so you can get a little bit more input from some of the business owners. Thank you.
Okay. I think, and we also have, of course, the Courier's best reporter sitting back there, and she's going to let the whole city know that that we are discussing this particular thing. Right? Okay. Anybody else in the audience? I saw another hand.
Good morning, gentlemen, and Darla, Frank, George. My name is Jim Grissett, 136 South Montezuma, and I think I was the original applicant that precipitated this request. Okay, I'm the culprit. And I appreciate you taking a look at it. What's interesting about the downtown business district, and you mentioned parking, was that I believe in perusing the parking rules that you also have the option of leasing spaces or buying spaces in the structure on Granite Street, which affects my lot because I'm right behind it. Is that correct?
The leasing of spaces, as we discussed before, is an opportunity for businesses to do, but that is not used to meet the parking requirement. That is, you could lease spaces, but it doesn't meet the standard for parking because the lease can be discontinued at any moment. So right now, the leasing of spaces, say in the Granite Street garage, could not be used to satisfy the all-street parking requirement. Something you could do on your own,
sure.
but it wouldn't be a permanent arrangement, which is what Mr. Marshall was concerned about.
But wasn't there something at $12,000 a space?
That's not something that's the fee in lieu of. Yes, that's the fee in lieu of.
So that would be the alternate for additional parking.
Correct.
So that's available. And the reason I thought that was appropriate to my property, which is at the Whiskey Row crosswalk there, was directly behind my building, which is that single-story building where the Harley-Davidson store and Wild at Heart and Mountain Spirit Gallery is. So I've got space right behind the building. So I thought it would be great because the parking is right there. And I actually I talked to Mick Finich, and then I also spoke to the engineering firm and architectural firm that did the parking lot for this city. And I said, you know, it would be kind of cool, if possible, if we could cut in an access to the central part of the parking lot onto the Granite Street alley. And I think I came up with a way that could be done. It's just a matter of cost and so forth. So I thought, well, in addition to my unique location, which is right at the center of the parking structure, all the ADA requirement access to the parking structure is on Granite Street. There's an elevator and stairway. And then they've got the 2 stairways that are getting kind of rusty now that they're going to, I guess, recondition. And I thought one in the middle would be kind of nice too, and perhaps I could contribute something or pay for that to get access to my project. What originally got me going on this, I was looking at different properties, additional properties to buy downtown, and in looking at the zoning and the 58 dwelling units to the acre for residential, I also explored the idea of putting some hotels in some areas in the downtown business district. And if I'm not mistaken, and Frank can verify this, on a lot you could virtually put in as many hotel rooms as you wanted within the 50 feet, as long as you met all the code requirements, ingress, egress, elevators, and all that stuff. But there was absolutely no parking requirement, which obviously you'd be an idiot to build a hotel 50 feet high with 1 million units in it and no parking.
Right.
But that's the thing that got me going on this. I thought, well, the parking is an interesting issue because you can build a hotel downtown, and if you're a real adventurous and risk-taking hotel developer, perhaps you could do that. And you think, well, I'm not getting any parking. Well, they can park in the parking structure. You can have I looked at having valets run the cars back and forth and so forth, which would be totally within the current zoning. So I thought, gee, we have a parking requirement for apartments, but we don't have a parking requirement for hotels. Now, what's to keep someone from living in a hotel forever? I think J. Edgar Hoover lived in the Waldorf Astoria for 36 years. So in essence, a hotel becomes an apartment. So to me, it seemed like even though you need to have parking, the fact that I'm on the Whiskey Row Alley and adjacent to a parking structure, and I want to have parking, but it seems like the same parking requirements ought to apply to a residential structure along that alley as would apply to a hotel. So anyway, those are some of my thoughts.
Interesting thought, food for thought there.
And I really appreciate you guys taking a look at this.
Sure.
And once again, I speak in front of city councils in big cities and places like that. You guys are the nicest guys I've ever dealt with.
Hey, we appreciate that.
You probably say that to everybody.
I've been a property owner in Prescott for over 25 years, and I've maintained a residence in Prescott Valley, out in Coyote Springs, for 10 years. Thank you so much.
Well, thank you for your comments. Food for thought.
Obviously, projects are built with a real long life span, and Ford is saying in 5 years we'll have self-driving cars, electric, and in 10 years, you're going to push a button on your phone and a car will show up. We won't need the parking that we have today.
Let me make one additional comment regarding the Uber comment. My goddaughter, who's 16, she verified that. She said, some of my friends aren't even given their driver's licenses. And I said, should we just take Uber? And I said, you kidding me? I said, do you really want to get in a car with potentially some creep to drive you around? And she goes, no, we all do it. She goes, my dad gave me a card just for Uber. And that's how they shuttle to all their games, all their sports activities and everything else. And my stepdaughter, same thing. She drives an electric little teeny car, and they have electric parking for her, at her place she works. So the whole world is changing, with all the major car companies now talking about driverless cars and all this kind of stuff. I mean, it may become a moot point, the parking issue at some point in time, probably not in our lives. Thank you.
Well, especially in a downtown business district situation. So it's an interesting food for thought there.
And except within the major events of the year, the Christmas tree lighting, the rodeo, and some of the other big events, that parking lot is virtually vacant on the upper floors, as I've checked it out many times. Thanks.
That's good, though. Okay, anybody else like to speak? And then I'll get to you, George.
Yeah.
Good morning. My name is Catherine Knight Roosing, and I just wanted to...
I need an address, Catherine.
1904 Young Place up off Copper Basin Road. In
Okay.
fact, I'm a neighbor of Mr. Lamberson. Hi. I just wanted to express my support for the Downtown Business District. I think it's a forward-looking project. I wanted to thank Frank for all of his hard work. I was one of the few people that was at his initial meeting, and I just wanted to say, just because there aren't throngs of people here doesn't mean people aren't interested. I think there's a lot of support for it, but there's a lot of people that are still working and can't come to the meetings. And also, the Courier does a good job documenting these meetings, and people follow it in the Courier. But I just wanted to add that I went to the University of Arizona in Tucson back in the 70s when the dinosaurs were still roaming the earth and the Earth's crust was still cooling. And back then, University of Arizona is very close to downtown Tucson, and we would never think to go to downtown Tucson back then. It was just flea bag hotels, run down. It was dark at night, crime-ridden. Nobody would risk it going down there. And now you go down there, they have a light rail system. It's very vibrant. There's art, culture. They have restaurants, theaters, so many activities, outdoor activities, urban residences. And when you visit Tucson, you don't want to miss going to downtown Tucson. So I just wanted to thank everyone for the effort in preventing that from happening to our wonderful downtown. And I look at this district as throwing off a lot of archaic rules and regulations from back in the day, and encouraging more life downtown. And an aside is, I was wondering about the bed tax. If you're increasing the density, has anyone thought about increasing, the coffers, more money to the coffers with that 2% bed tax with more residential? Would definitely be a positive thing. So thank you very much.
Well, thank you. Thank you. Basically, we have the same feelings. We've encouraged that for ever since I've been on the commission, and of course the new general plan certainly pushes it hard as far as increasing, keeping the downtown vibrant. So, George, you had a question.
Yeah, well, he brought up hotels, but maybe John can answer this. We've got all these different categories. If you live here this long, or if you're in town for this long, 30 days, you're a permanent resident, or we're talking about the group homes. We're talking about different categories of length of stay. We're talking about vacation rentals. At what time? If you're staying in a hotel, when are you more considered a permanent resident, or I don't think you are, but
36 years.
Huh?
36 years.
Well, the way our
yeah.
Well, the way our tax code is the city does charge the TPT, the sales tax, on residential rentals which are 31 days or more. Not the bed tax, which is based on a more transient, less than 30 days. So apartment rentals or single-family home rentals do pay the 2% TPT. Vacation rentals actually are treated like hotels. So a vacation rental for fewer than which is fewer than 30 days would pay not only the 2% TPT but the 3% bed tax, similar to a hotel. It's not the distinction isn't based on sort of an individual, how long an individual stays. It's really based on sort of the nature of the rental. So if I own a home and I'm going to lease it out to someone for a year, part of the rent or part of the cost would be that 2% TPT. If I in turn, or if in lieu of that, decide to rent it out on a week-to-week basis or a 3-day minimum, for instance, and somebody, let's say there's a traveling nurse or something that wants to rent it for 3 months, it would change it from the TPT plus bed tax to just the TPT tax. So it's really the nature of the rental. So if somebody stays in a hotel for 2 months for some reason, if J. Edgar Hoover, decides he wants to cross-dress and stay at the Spring Hill Suites for 2 months,
John.
he's dead. I can't defame him. But it's proven. But anyway, I don't judge. Not, within Seinfeld, nothing. Not that there's anything wrong with that. But anyway, point is if somebody decides to stay at Spring Hill Suites for say a 2-month period because they're working here, the Spring Hill Suites would still. Basically it's a day-to-day charge. So the hotel would charge not only the TPT but also the bed tax. Right. The challenge sometimes is for single-family residential or apartment residential type uses. It's based on the actual rental, but if it's a hotel or a B&B or something that's really more of a commercial use, then regardless of the length of time, they're going to be paying the bed tax plus the regular TPT. So yes, if you put residential uses downtown and they're rented versus I think the prior project looked like it was more of a condo type use, the rentals would generate at least the sales tax portion, 2% of whatever the monthly rent is.
Yeah.
Okay.
Starting to get the cart before the horse. We're already collecting revenue on these places, but I think that just shows what a complex issue this is. When you start changing rules, even though they may be understandable, you realize the domino effect that it can have on other issues. I've heard today downtown business district. I've heard residences downtown. I've heard the traditional downtown. Apparently, we have several types of downtowns here, and we have to be careful. And I remember Dave and I were chatting yesterday, and a very good friend of mine said that with me, even having been here 32 years, he still calls me a carpetbagger. But I've been here long enough to realize that some of the houses downtown are gone. The property you were referring to on Montezuma, where the single family is being built, that was a house, and it did have setbacks, by the way. And the city parking lot next to the legal office was a house, and it had setbacks. So those comments aren't new. I mean, those were part of a downtown, and I'm just glad that we've had the opportunity to have a real open discussion on this. And that not only the downtown partnership, but the historic group is involved in it too, because I think it's really more complex than how many units you put on a 7,500 square foot lot in downtown Prescott. We have so many other rules because we have a bigger city than just downtown that it takes to support the downtown, by the way. We have a lot of the buildings. We haven't even touched on the buildings. Well, we haven't touched deeply on the storefronts that have empty space upstairs and have been for 40, 50, 60 years. That is, in my opinion, ideal fodder for having apartments. And then you got the parking issues with that. So it's a complex issue, and I think this community needs to take just as much time as it's taking to figure out how to do it. So we don't do something impulsively and make downtown regret what happens. My thoughts. It came about when we started talking about how much revenue we're going to get out of these 6 extra apartments.
Okay, anybody else like to speak to it? Okay, we're going to we're going to keep the public hearing open until October 13th meeting.
Yes, sir. We can come back October 13th, if that's what you want.
We need to vote on that?
Yes, sir. I don't know. Do we need to vote on that?
No? Okay.
No? Okay, publicly stated.
It's not really a postponement, it's a
continuation.
Continuation. Okay, we're going to continue this public hearing until October 13th, and that's all the action we're taking on it today.
Correct. And Mr. Chairman, you asked what I'd like to do for the additional information that I showed you on my slides that I did at that public meeting. All of you get email from Darla. What I'd like to do is I have that as a PowerPoint presentation. I can email it to you.
Sure.
Or I can snail mail it to you, whichever you prefer.
Perfect. That's fine. Email it, and if we need to pick up a hard copy, we will.
Okie doke.
Okay. A summary of current recent events. Don't we have something coming along the pike on vacation rentals?
Well, as I mentioned, Mr. Chairman, we will. The council will be looking at vacation rental regulations performance or operational type regulations.
Okay.
Simultaneous to that, the code, the land development code will have to be changed to allow for less than or fewer than 30-day rentals. Because right now we ban those. So the state law that goes into effect says we can't prohibit vacation rentals beginning January 1. So what the goal of that is, if we're going to implement some type of operational or performance type standard, that has to go into effect prior to January 1. So we'll bring that ordinance, the sort of operational performance ordinance, to the council on the 11th for a study session, and happy to put that on the agenda on the 13th to sort of brief this.
But there'll
the commission.
There'll be land development code changes.
There will be. They're really, for all intents and purposes, they're going to be housekeeping because we really don't have any choice. So mostly definitional type changes.
Okay.
You know, and even if we didn't change the land development code, we still have to allow them. So it just makes it easier, I think, for people to see. And so we adopt those. But at the same time, we'll adopt some performance standards that require contacts, and so that if there are impacts from vacation rentals after January 1, our staff will have the ability, whether it's code enforcement or PD, to be able to make contact with the appropriate person, whether it's a property management type person, the owner or whomever, to make sure that we try and mitigate impacts of vacation rentals.
And those vacation rentals will fall under the business licensing?
They will. They'll have to get the operator will have to get a
Okay.
business license, and they'll pay both TPT and bed tax for those types of rentals. So, I mean, from my understanding, even though they're not technically allowed under our zoning code, we still collect TPT and bed tax on those types of uses currently.
Right.
So, but yeah, by way of the business license, we should be able to gather a better idea of where our vacation rentals are in town. In fact, the city manager is also looking into hiring or contracting with a company that actually can track, because basically vacation rentals are an online business now through Airbnb and vacation rental by owner, those types of things, and it's all done through PayPal. To be honest, I mean, so we'll be able to track those though by having a company probably look at, sort of monitor the internet and probably sweep in 90% plus.
Good.
There's always going to be those outliers.
Good. Yeah, okay.
I think,
Thanks a lot.
just
George?
on that, as I understand, HOAs are exempt from that, so if they have a 12-month minimum lease term, that this will not impact theirs, so you'll basically not be able to have vacation rentals at HOAs.
That would all depend on the CC&Rs of the HOA and the enforceability. We don't. Yeah, that's outside of our zoning purview. So, but as a function of zoning, we have to allow for less than 30-day rentals, vacation rentals, however you want to define those.
Right. Okay. Thank you. Any other questions? Mr. Lamerson.
No question. Not only as a member of the council, but as a resident, longtime resident in the city, appreciate you looking at this issue with the density in the downtown. Appreciate you keeping in mind the general plan, as has been pointed out here, overwhelmingly passed by the residents of this community. Looking at who's sitting on our Planning and Zoning Commission, I appreciate you all acknowledging the silver hair, but not denying the fact there's other people that live here too. My daughter, a millennial, rented a 450 square foot apartment, 1 bedroom, 1 bathroom, for over 6 years, and lived in the downtown. She could walk to work, could walk to the grocery store, could walk to the restaurants. Her husband, who worked 2 jobs, worked downtown serving many of you in restaurants, and they had a place to live, work, and play. All right?
Yeah.
Because of the availability of something different than a 3,500 square foot home on an 1.5 acre lot in some sort of subdivision that had all kinds of requirements. So I think as Ms. Rusing was pointing out, or Dava was pointing out, many of the folks out of our generation are going to be looking at something different than just these big houses on big lots with the convenience of living somewhere close to shopping, close to medical, close to eating, close to having a community deal. And as we go forward in the process of looking at the codes, which many of us have been working on for many years, none of us want to see the character, the historical nature of our town go away, but part of that character and historical nature included people. That's part of the infrastructure that has evolved Prescott being Prescott. And the more that we regulate people from having the opportunity to live here, or the free market and private property owners from developing to the demand that's in the marketplace, the less opportunity we have to be the real Prescott of the year, maybe not 1894, maybe not 1952. But what's wrong with being what Prescott chooses as Prescott to be in the year 2020, which you acknowledge the millennials, you acknowledge the silver hairs, you acknowledge the convenience for both. And I really think it's an opportunity within our codes, in the alterations of our codes, under the guidance of our staff. We are addressing the water issues, we're addressing the road issues, the infrastructure issues, etc. I think we have an opportunity to look at doing some things, thinking of not only 7,500 square feet, but multiply it times 50 feet. All right? Look at the opportunity that's here for people actually to work, live, and play in Prescott. So thank you very much for continuing this, because I think you do need to have public dialogue on this.
Oh, absolutely.
All right?
Absolutely. Thanks, Jim. All right, anybody else? No? Okay, we're continuing this hearing, and we've got everything else taken care of. We're adjourned.
Glenn wants to go home.
Snap that.
Glenn wants